Well, hello everyone. My name is Mark Halsey and I'm here with Fiona Halsey, and we are Halsey Legal. We're here today to discuss a recent AFCA case, a case dealing with non-disclosure and life insurance. It is an interesting case based on some interesting facts with arguably a surprising outcome. It's a case that will be of interest to insurance companies, but also to financial planners, particularly those involved in handling or assisting clients with claims handling procedures. So without any further ado, let's get started. Fiona, can you give us the background to the case?
Thank you. Yes, the case is interesting in that it involved a psychologist who made an application for life and TPD cover. Mm-hmm. So she made the application and the policy was issued in February 2019. So she probably made the application in either late 2018 or early 2019. Mm-hmm. And at the time of making the application, she, in the standard kind of application form that you have for life cover, she answered yes to the question of whether there'd been any mental health disorders. Mm-hmm. And when she answered yes to that question, then obviously that then triggered off the usual mental health questionnaire. And the results of that mental health questionnaire are so interesting that we're going to put them on the screen because I think you'll be, once you read them, it puts a lot more context into the case. Mm-hmm. So I'm just putting these up now. Now, you can see from this that the mental health disorders asks to describe your symptoms, including the date started and how long they lasted. She wrote that the symptoms started in 2014 and would be anxiety, fatigue, stress and low mood, that it lasted for a couple of months before seeking GP's help, lasted for 3 months. There was then a specific question as to whether or not there was a reason that it had been triggered, and she said that there had been postnatal depression, that she'd had a baby and was hormonal. Then there's this clear statement about the date her symptoms had commenced, which was the 1st of March 2014, and then the date of the last symptoms, which was the 1st of June 2014. It then continued on to there was a question of, have you had any recurrences of the condition? She said no. And then a question about advise all treatment that you have received and include still receiving. And in this, she stated that she received medication from the GP and was still currently taking that medication at the time in either 2018 or 2019. So it was clear that that was what was occurring. Mm-hmm. Now, the other thing was that there was a questionnaire in respect of alcohol dependency and treatment. And she answered no to that. Now, interestingly, AFCA doesn't give us that form. They've only given us the form in respect to the mental health disorders. But in respect of the question of the alcohol dependency, there was apparently a question which asked if she'd ever had treatment of alcohol dependency, to which she answered no. However, in the way that with virtually every life insurance claim I've ever seen, the insurance company has asked for the medical notes from all of the medical professionals that she's consulted over the years. Yep. And when the life insurance company obtained those notes, they discovered that in 2017, she had requested a treatment from her general practitioner of diazepam on the grounds that she needed that to help her because she was going to reduce her alcohol intake from 1 bottle of wine a day to half a bottle of wine a day. And that she needed this for support to allow her to do that. Yep. So quite a, obviously quite, a thing to have that kind of drug prescribed to allow you to transition off the alcohol. Sure. So then the final fact is the sad fact, and that is that in 2020, in July 2020, she unfortunately passed away. So then her estate made a claim on the policy, and the insurance company avoided the policy.
Okay, so those are the background facts. What was the AFCA finding and what was their basis for reaching the decision?
Well, very interesting. AFCA found that the insurance company could not avoid the policy and that the estate should be paid $542,500, and that it should also pay interest from the time it avoided the policy. So, and that's the largest amount that AFCA can pay in this kind of case.
Sure.
So it's a very substantial amount.
Yep.
And so you were also asking about the background to how they came to that conclusion?
Yeah.
Yes.
There seems to be a very obvious case of non-disclosure, particularly of the alcohol.
Well, I would have thought of, I mean, I personally thought of both, but I think you're right. Yes, that's true. But AFCA, in respect of the mental health, concluded that the insurer should have been on notice by the fact that the medical treatment was still ongoing. So the fact that she was still on medication at the time of making the application, they should have realised that clearly the mental health issues had not gone away because she was still on the drugs.
Right.
So yeah, they came to that conclusion. And your other question was in respect of alcohol.
The treatment.
Exactly.
The prescription for diazepam was clearly targeted at trying to reduce alcohol consumption. That was the purpose.
Well, that's exactly right. Yeah. Yes. However, in that case, what happened in respect of that was that AFCA found that first they just seemed to just skate over the issue of non-disclosure. But then what they did is they then considered that whether the insurer would have provided the policy if they had been properly informed about the alcohol and the diazepam. And what they did is they then looked at the internal policies of the insurer and considered what the insurer would likely have done. And the insurer put forward its policies and it put forward evidence from two senior staff members as well, who said that in that case they would not have granted the policy. But AFCA didn't agree with that. And AFCA looked at it and decided that the insurance company had a number of different categories which related to whether somebody had treatment for alcohol dependency, and that there were three categories, and that it was only certain that in the most severe category that they would not provide a policy to this person. In that regard, they then found that this was not the most severe case.
Right.
Okay, and you can understand that. When you think about really severe alcohol dependency cases, this is probably not that. And they then found that as a result, the insurer couldn't prove that it wouldn't have given the policy.
Right.
And as a result, the insurer was not able to avoid the policy.
Right.
So found for the complainant.
Right. So do we have any takeaways as a result of those circumstances and the way in which AFCA came to its conclusions?
Okay, so I think this shows very clearly that if you've got a case where you've got a question of non-disclosure, it is always worth having a good look at it. So particularly, I can't help but think that in this case, this was a sad case. So what you had the psychologist, if the postnatal depression had been in 2014 and the death was in 2020, at the time of the death, it seems likely the child is probably not more than 7 years old. And you can't help but think that AFCA would have been, very sympathetic in that circumstance.
Sure.
We don't know what the psychologist died of, but you can see a significant, probably significant sympathy, because when you look at this case, you're thinking maybe, it doesn't seem like a completely black letter law situation to me. But your question was, well, what's the takeaway from that? And I think the answer is simply that if you think that if there's a relatively large amount of money in play, that it's worth looking closely at it and probably worth getting some external assistance in respect of the Insurance Contracts Act and other associated legal issues, because there might be a win at the end of it, which is particularly satisfying if you're the advisor and you've written the policy to start with. Very, very nice feeling if you've written the policy and you can be involved in finally getting the, you used to say the cheque, but now getting the
Yep.
deposit, isn't it?
Absolutely. So, in a nutshell, even though advisors have been involved in claims handling for years, it's arguably for risk specialists, it's part of their core services. And a lot of them rely on actually reading the legislation, reading the terms of the policy, etc. And probably the answer to this is never say die. What you understand to be the black letter might be flexible in terms of the way in which you make your submissions and argue the points.
I would absolutely agree with that.
Okay.
Yes, I would absolutely agree with that. That in a circumstance that you think that, I think it's worth a try.
Terrific. Well, that concludes the talk for today. I hope you've obtained some benefit from it. I certainly have. It's been a very, very interesting set of circumstances behind this determination. And thank you for joining us.
Now, just one further thing, that is that we have we've put on the websites for both Halsey Legal and Licensee Solutions. We've uploaded a note about this determination. So if you'd like to read that in slightly more detail, it's on our websites, and you can see our websites on the screen now. We hope you've enjoyed this, and have a great day.
Bye.
Goodbye.